What I'm concerned, on the other hand, is that there are every time there is expanded definitions or increased involvement of criminal law, especially when it comes to sexuality, I'm becoming a little bit concerned. I mean, what might going to be the result for that?
A case being looked at Canada's highest court could have implications on the definitions of assault and consent. At the centre, a 2017 sexual encounter between a BC man and a woman. She said she'd consented to sex but asked him to wear a condom, and he didn't. Kate Feeney is with West Coast Leaf, one of the interveners in this case.
There's a tension between the case law on condom removal, stealthing, and condom sabotage, and the case law on HIV non-disclosure. West Coast Leaf is really concerned about the inclusion of HIV non-disclosure in sexual assault law, and we'd like to see it be removed from sexual assault law in order to reduce the overcriminalization of people living with HIV, including women living with HIV.
Aaron Purdy and Evan Machette-Wong are both with the Health Initiative for Men. They agree there could be problems down the line for the gay queer community, with condom use often tied to HIV disclosure. With medications that make HIV nearly intransmissible, advocates say this could lead to more stigma.
With the paradigm of HIV, which has been criminalized for many, many years, we have seen firsthand the impacts of what happens when we criminalize a virus, which is not the same as criminalizing a behavior, but we understand that there are some interesting implications to that criminalization if that were to occur.
With medical advancements, law and policy also have to follow suit in it. We can't reliably use laws and policies that were written before certain medical advancements, especially in the case of HIV. And a lot of this is not only determined by lawmakers and policymakers, but also by judges in the courts who decide on cases.
That's why both Machette-Wong and Purdy say sexual health education and consent education must be top priority.
I think the biggest component is really trying to secure enthusiastic consent. So as opposed to no means no, it really should be an enthusiastic yes means yes. It's less ambiguous, it's more direct, and it can prevent a whole lot of complications.
Trauma, complications, pregnancies, unwanted STIs.
For now, the justices at Canada's highest court have taken the info from the hearing under advisement. In Vancouver, Ria Renouf, City News.